Greetings, Friedman family and friends. Thank you so much for joining us this evening. Hope you're having a fantastic day and week. Welcome to our live weekly YouTube readings of the final report of the California Reparations Task Force, right here on CJEC YouTube channel. This is the only live reading of the California Reparations Task Force final report on YouTube. The final report of the first in the nation California Reparations Task Force is one of, if not the most important government reports about the Black American community since the 1960s. Equally important is also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing every page of it to you, chapter by chapter, every week on Thursdays at 7 p.m. PST, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with the support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more info on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California state prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now I need you to do three things. First, connect to our YouTube channel by 1. Liking this video. 2. Hit the bell for reminders. 3. Subscribe to our YouTube channel. Second, get connected to us on all social media by following CJEC on Instagram, TikTok, Facebook, and Twitter at CJEC Official. Finally, get informed and involved. To do that, visit www.cjec-official.org to sign up for current and accurate California reparations news and info on our Get Involved page, and support our work by volunteering and or donating. To donate, just click the Donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. You can learn more about our fiscal sponsor, the California Black Women's Health Project, at www.cabwhp.org. By way of introduction, my name is Kim Mims. I live in Sacramento, California, born and raised. I'm a first-generation Sacramentan by way of the Great Southern Migration. Also, I'm a co-founder of Amend the Mass Media Group, along with my formidable partner, Yamoya Glass, who you heard from last week as Chapter 34 volunteer reader, and volunteer reparations advocate with CJEC's Reparation Organizing and Mobilizing Team. The agenda for today, Chapter 35 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight, Housing, Federal Statutes, and Case Law. You can follow along in the reading, download tonight's chapter or the full report yourself by going to our website, www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as some listeners may know, ETM Media Group read the interim California reparations report, and you can watch those readings of the first report on our channel at ETM Media Group on YouTube and on CJEC's website at www.cjec-official.org/videos. Second, for those of you who don't know, historic reparations legislation in California is here, and more is coming. CJEC is actively tracking reparations bills authored by Senator Stephen Bradford as they make their way through the current legislative cycle. SB 1403 is lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. SB 1331 is lineage-based legislation which will establish the Fund for Reparations and Reparative Justice, and SB 1050, which instructs the California American Freedmen Affairs Agency to address racially motivated eminent domain. To read the bills, visit www.cjec-official.org/advocacy. Third, as mentioned, more historic reparations bills are coming and will be written for future California legislative cycles. The three reparations bills I mentioned, authored by Senator Stephen Bradford, all passed the 2024 Senate floor vote and will now make their way through the Assembly. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. So to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Once the bills pass the Assembly, we need Governor Gavin Newsom to sign them into law. While I'm here, I'll also mention that SB 1007 and SB 1013, the lineage-based housing assistance and property tax relief bills, also written by Senator Stephen Bradford, did not pass the 2024 Senate floor vote. So there's still much work to be done to address California's current and historical anti-Black American freedmen housing harms. And without further ado, Chapter 35, Housing, Federal Statutes, and Case Law of the California Reparations Task Force Report. Chapter 35, Housing, Federal Statutes, and Case Law. 1. Federal Statutes and Case Law, 1862. The Homestead Act of 1862, 37 Congress, Chapter 37, 12 Statute 392, repealed by Federal Land Policy and Management Act of 1976, 43 U.S.C. 1701 to 1787. Chapter 35, Intro, Take 2. Housing, Federal Statutes, and Case Law. 1. Federal Statutes and Case Law, 1862. The Homestead Act of 1862, 37th Congress, Chapter 75, 12 Stat. 392, repealed by Federal Law Policy and Management Act of 1976, 43 U.S.C. 1701 to 1787. Summary of the facts and issues. The Federal Homestead Act of 1862 gave any person over the age of 21 or head of household who or intended to be a citizen and who had not taken up arms against the United States the opportunity to claim ownership of up to 160 acres of land. To own the land, the homesteader had to live there for 5 years and to make improvements to the property. Impact of the law. The act was a federal land policy that promised land ownership to citizens and was central to westward colonization over and against sovereign territorial claims of indigenous peoples. Since African Americans were not granted citizenship status until 1868, most homesteaders were white. 1866. The Civil Rights Act of 1866, 42 U.S.C. 1981. Summary of the facts and issues. The Civil Rights Act of 1866 guaranteed all citizens, regardless of race, the same rights to purchase, hold, and convey real property as was enjoyed by whites. But it did not prevent private agreements prohibiting African Americans and other non-white groups from owning homes in particular areas. Impact of the law. While the act was one of the first attempts at remedying the grossly inferior legal and social status of African Americans during the Reconstruction period after Civil War. The act did not dismantle the system of residential racial segregation following the Civil War. The gaps in the act's coverage meant that through private agreements and other actions, neighborhoods would remain segregated, even after segregation was declared unconstitutional. Neighborhoods and these consequently schools and other public facilities had not been integrated, and a disproportionate amount of public resources had flowed into white neighborhoods, cementing segregation, in fact, even where it did not exist in law. 1914, Jones versus Jones, 234 U.S. 615. Summary of facts and issues. When a freed African American man died without a will in Tennessee, his widow claimed she inherited his property pursuant to a state law. The deceased brother challenged this, contending the land passed to the deceased siblings who were also born enslaved as his heirs at law. The Supreme Court relied on Civil War precedents to hold that slaves were not within the meaning and effect of the statutes of descent, and no descent from or through a slave was possible except as provided by some special statute. Since Tennessee had only conferred the right to inherit upon children of formerly enslaved persons and not collateral descendants, siblings, the Supreme Court held that siblings were not heirs at law capable of inheriting real estate, and the 14th Amendment did not prohibit a state from denying inheritance to formerly enslaved persons. Impact of the ruling. Even though Mr. Jones acquired the land after he had been emancipated, the U.S. Supreme Court held that statute did not violate the Equal Protection Clause, despite limiting the rights of his formerly enslaved collateral descendants to inherit. This case made it more difficult for African American people to acquire and retain wealth through property ownership. Subsequent history. Although in 1919 Tennessee amended the statute to allow inheritance for collateral descendants of enslaved persons, this case still cited in a secondary source about inheritance for the proposition that the right to inherit property can be abridged by the legislature. 1917, Buchanan versus Worley, 245 U.S. 60. Summary of the facts and issues. A Louisville, Kentucky ordinance limited to use of a residence by a person of one race if the majority of residences on the block were already inhabited by a person of another race, with the aim of enforcing residential segregation. The effect was to limit the ability of African American people to buy houses on majority white residential blocks and vice versa. When an African American purchaser no longer wanted to complete a house sale because due to the ordinance, they would not be able to occupy the house due to their race, the seller brought suit to force the sale. Impact of the ruling. The U.S. Supreme Court held the ordinance violated the 14th Amendment because it violated the property rights of the seller to dispose of their property as they chose based on the race of the purchaser. While the court reiterated that some mandatory segregation of the races was permitted under the 14th Amendment, it interpreted by Plessy versus Ferguson, the court held that government impositions on the right to own, use, or dispose of property violated the protections in the 14th Amendment, in part because it impacted the property rights of white sellers. 1926, Corrigan versus Buckley, 271 U.S. 323. Summary facts and issues. A group of property owners in Washington, D.C. entered into a contract called Racially Restrictive Covenant, agreeing not to sell their property to African Americans. Later, one of the property owners sold their land to an African American, and another property owner sued to block the sale. The Supreme Court held that because the restrictive covenants arose from agreements between private individuals rather than state actors, the court did not have jurisdiction, since the Fifth and 14th Amendments only protected individuals from actions of the government. The court rejected an argument that the judicial enforcement of such covenants was state action because the issue had not been raised below. This case is different from the above discussed Buckman versus Worley, where the court was reviewing a municipality's ordinance government action prohibiting the sale of land based on the race of the purchaser. Impact of the ruling. Private individuals were allowed to enter into contracts limiting the disposition of their property using racially restrictive covenants, allowing for individuals to practice racial discrimination without violating the Fifth, 13th, or 14th Amendments. Approval of the racially restrictive covenants and their enforcement in court allowed for continued and increased racial segregation and severe limitation of property rights and wealth for African Americans. 1948, Shelley versus Kramer, 334 U.S. 1. Summary of facts and issues. Certain landowners in St. Louis, Missouri, entered into a racially restrictive covenant to prevent the sale of certain parcels of land to African Americans, and in 1945 brought suit to prevent the sale of a specific property to an African American owner. The court did not repudiate Corrigan versus Buckley, holding that racially restrictive covenants as agreements between private property owners did not raise constitutional issues. Still, the court held that judicial enforcement of such agreements constituted state action and prevented enforcement of racially restrictive covenants under the 14th Amendment's Equal Protection Clause. Impact of the ruling. Well, the court did not prohibit racially restrictive covenants as such. It expanded the view of state action covered by the 14th Amendment to encompass judicial enforcement of such covenants in state courts, building on Hard versus Hodges prohibition applicable to federal territories, making them no longer enforceable in court to prohibit sale of property to African American nationwide. The case did not, however, make any impact on the then developing practice of redlining, which depended upon the granting of mortgages by the federal government rather than the practice of imposing racially restrictive covenants. 1967, Hurd versus Hodge, 334 U.S. 24. Summary facts and issues. White property owners of a group of houses in Washington, D.C., subject to a racially restrictive covenant, sued to reverse the sale of properties within the covenant to African Americans. The Supreme Court held the court enforcement of such racially restrictive covenants violated Section 1 of the Civil Rights Act of 1866, codified at 42 U.S.C. Section 1981, which provided that all citizens have the same right to sell property regardless of race. The court did not overrule Corrigan versus Buckley, holding that such private restrictive agreements are not invalidated as long as they are achieved through voluntary adherence, but held to judicial enforcement was government action that violated federal law and public policy. The court held it need not reach whether the action also violated the Fifth Amendment, since it could resolve the case on statutory grounds. Justice Frankfurter concurred, stating that court action enforcing the covenant would violate the Constitution. Impact of the ruling. The court's decision prohibited judicial enforcement of racially restrictive covenants in federal territories, including Washington, D.C., but held the voluntary use of such covenants was acceptable additionally. The majority decided the case based on statutory rather than constitutional grounds, potentially allowing a future Congress to determine the case with a repeal or amendment of the federal statute. Reitman v. Mulkey, 387 U.S. 369. Summary of the facts and issues. In 1964, California voters passed Proposition 14, which added Article 1, Section 26 to the California Constitution and prohibited the state from denying, limiting, or abridging directly or indirectly the right of any person who is willing or desires to sell, lease, or rent any part or all of his real property to decline to sell, lease, or rent such property to such persons or persons as he in his absolute discretion chooses. This in practice overturned the state laws prohibiting racial discrimination in the sale and lease of residential housing. And the case arose out of two consolidated cases where persons refused to rent to or attempted to evict tenants due to their race. The U.S. Supreme Court upheld the decision of the California Supreme Court, finding Section 26 unconstitutional because it involved the state in racial discrimination in the housing market. Section 26 was legislative action which authorized private discrimination and made the state at least a partner in the instant act of discrimination, while rejecting the notion that state was required while rejecting the notion that a state was required to have a statute prohibiting racial discrimination in the housing market. The court held Section 26 went beyond and constitutionalized the private right to discriminate in a way that significantly involved the state in private racial discrimination, contrary to the 14th Amendment. Impact of the ruling. The court expanded the notion of state action here to allow for repudiation of an amendment that constitutionalized the private right to discriminate on racial grounds in housing. The case reinstated state fair housing laws and allowed their continued expansion in the state. Subsequent history. The Supreme Court distinguished the holding of Reitman in Shute versus Coalition to defend affirmative action, integration, and immigrant rights, which upheld the state of Michigan's constitutional amendment prohibiting affirmative action. The court emphasized that the amendment in Reitman expressly authorized the constitutionalized and private right to discriminate, which significantly encouraged the involvement of the state in private racial discrimination. In contrast, the court held that a voter-approved constitutional amendment banning affirmative action did not address or prevent injury caused on account of race, but rather allowed voters to determine whether a policy of race-based preferences should be continued. 1968, Jones versus Alfred, H. Mayer Co., 392 U.S. 409. Summary of the facts and issues. African Americans filed a lawsuit after the respondents refused to sell them a home in Missouri due to their race. Petitioners alleged the refusal violated 42 U.S.C. Section 1982, which provides all citizens the same right as is enjoyed by white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property. The lower courts rejected the claim, holding the statute applied only to state action and did not reach private refusal to sell, but the Supreme Court reversed, holding that Section 1982 bars all racial discrimination, private as well as public, in the sale or rental of property, and that the statute thus construed it is a valid exercise of power of Congress to enforce the 13th Amendment. The court held that Congress has the power under the 13th Amendment to rationally determine what are the badges and incidents of slavery and the authority to translate that determination into effective legislation and protection of the right to purchase property clearly fell within this authority. The court provided a broad view of the power of Congress to pass statutes under the purview of the 13th Amendment directed at eliminating the badges and instances of slavery, particularly as related to fundamental rights that are the essence of civil freedom, like purchasing property. But the court reiterated that the statutes and its decision did not reach beyond a racial discrimination, did not extend to advertising or other representations, including discriminatory preferences, did not address provisions of services or facilities in connection with the sale or rental of a dwelling, did not refer to discrimination in financial arrangements or brokerage services, and did not empower a federal administrative agency to assist or provide for intervention by the Attorney General. The Federal Fair Housing Act of 1968, discussed below, prohibited several of the types of discrimination that were not specifically outlawed by Section 1982. 1977, Village of Arlington Heights versus Metropolitan Housing Development Corp., 429 U.S. 252. Summary of facts and issues. A housing developer applied to the village for the rezoning of a 15-acre parcel from a single family to multiple family zoning in order to build townhouse units for low and moderate income tenants. The village refused, and the developer sued, alleging the denial was racially discriminatory and it violated the 14th Amendment and the Fair Housing Act of 1968. The Supreme Court upheld the denial, holding that showing a state action had a racially discriminatory impact was not enough to demonstrate a violation of the 14th Amendment. Instead, proof of racially discriminatory intent or purpose as a motivating factor for the decision is required to show a violation of the Equal Protection Clause, and the court did not find such proof in this case. Impact of the ruling. The court set out several factors for consideration in determining whether there is proof that a racially discriminatory purpose was a motivating factor for a challenged action, including extreme disproportionate impact, the absence of justification, historical background of the action, departure from normal procedural standards, and departures from typically applied substantive rules. The court's standards here foreclosed equal protection claims based only on discriminatory impact and set a high standard of proof for any claims to demonstrate the requisite discriminatory intent. 1978, Gladstone Realtors versus Village of Bellwood, 441 U.S. 91. Summary of facts and issues. The village of Bellwood and several white and African American residents therefore sued two real estate brokerage firms, alleging the brokers were engaging in racial steering, directing prospective home buyers interested in equivalent properties to different areas according to their race, in violation of the Fair Housing Act of 1968. The village of Bellwood alleged that it had standing to sue because it had been injured by having its housing market wrongfully and illegally manipulated to the economic and social detriment of the citizens of the village. The individual respondents alleged that they had been denied their right to select housing without regard to race and have been deprived of the social and professional benefits of living in an integrated society. Impact of the ruling. The Supreme Court held that standing under the Fair Housing Act is a broad and allowed under Article 3 of the Constitution and was broad enough to encompass the plaintiffs here and injuries alleged. This allowed municipalities and African Americans to challenge discriminatory real estate practices undertaken by private parties. 1981, City of Memphis versus Green, 451 U.S. 100. Summary of facts and issues. Pursuant to the request of white residents, the City of Memphis closed the northern end of a street in a predominantly white neighborhood, thereby restricting access and through the neighborhood by those living immediately to the north in a predominantly African American neighborhood. African American residents of the northern neighborhood sued, alleging the closure denied them the benefits of property given to white residents in violation of 42 U.S.C. Section 1982 of the 13th and 14th Amendments. Impact of the ruling. The court first determined there was no evidence of discriminatory intent in the closure decision, and thus plaintiffs could not sustain a 14th Amendment equal protection claim. The court then held that the closure did not show African American property owners would be refused a similar accommodation, that the value of African American property would be depreciated, nor that it restricted access to African American homes, and thus plaintiffs did not demonstrate an injury within the reach of 42 U.S.C. Section 1982. Finally, the court held plaintiffs could not sustain a claim under the 14th Amendment because the inconvenience of needing to use a different street, though it fell mainly on African American residents, was a function of where they live and where they regularly drive, not a function of their race. And despite the potential disparate impact on a segregated neighborhood, this type of municipal action did not rise to the level of a badge or incident of slavery that would violate the 13th Amendment. State case law and statutes. 1861, Williams versus Young, 17 Cal 403. Summary facts and issues. Miss Young, a mulatto or mixed race person and widow of Mr. Young, sought to defend against her ejection from the Williamsons' property by using state homesteading as a defense. Prior to Mr. Young's death, the Youngs purchased the property from Mr. Williams, but had not finished paying the entire price. After Mr. Williams passed, his wife tried to eject Miss Young from the property, claiming that the homestead defense did not apply to mulattoes and that she had a sheriff's deed to the lien of the property. Impact of the ruling. The court held that since Miss Young did not abandon the homestead, she could not be ejected from the home since the lien on the property was not enforceable. The title and right of possession remaining with Miss Young until the sale of the property settled. In this case, the California Supreme Court held that the Homestead Act applied to African Americans and mulattoes. 1879, Article 1, Section 17 of the California Constitution of 1879, amended November 6, 1894, repealed November 5, 1974. Summary of the facts and issues. With regard to housing and property ownership, California Constitution originally declared foreigners of the white race or of African descent eligible to become citizens of the United States under the naturalization laws thereof, while bona fide residents of the state shall have the same rights in respect to the acquisition, possession, enjoyment, transmission, and inheritance of property as native-born citizens. Impact of the law. In 1879, Citizen expanded to include people of African descent who were deemed eligible to become citizens of the United States. However, both white and non-white foreigners who could not naturalize and or established state residency did not have property rights. And in 1894, Article 1, Section 17 was amended to state that foreigners had the same rights in property other than real estate as native born citizens. 1959. Unruh Civil Rights Act. Civil Code, Section 51. Summary of the facts. The Unruh Civil Rights Act declares that all persons in California are free and equal, and no matter their race, no matter their sex, race, color, religion, ancestry, national origin, disability, medical condition, genetic information, material status, sexual orientation, citizenship, primary language, or immigration status, all are entitled to the full and equal accommodations, advantages, facilities, privileges, and services in all business establishments of every kind whatsoever. Impact of the law. As a result, the Unruh Civil Rights Act, enacted in 1959, California business establishments, including those providing housing and public accommodations, could no longer engage in unlawful discrimination by refusing to lease or rent to African Americans. This act has been interpreted by the courts to prohibit arbitrary discrimination by business establishers, further by enacting remedial provisions to the act through Civil Code Section 52, including allowing for actual and punitive damages in cases of housing discrimination violations. The legislature created a true enforcement mechanism for individuals to seek redress for discrimination. 1962, Seaborn Burks versus Poppy Construction Company, 57 Cal 2D 463. Summary of facts and issues. An African American couple bought an action for damages and injunctive relief alleging discrimination with respect to the sale of a house in a tract. The first cause of action was based on Unruh Civil Rights Act, which prohibits discrimination in business establishments. And the second was based on the Hawkins Act, former Health and Safety Code 35700-35741, which relates to discrimination in publicly assisted housing accommodations. Impact of the ruling. This case represents the first California Supreme Court case interpreting the Unruh Civil Rights Act. The court reversed the lower court's dismissal of claims under the Unruh and Hawkins Act against the defendants, building developers who were responsible for sales of publicly assisted houses on tracts of land. Lee versus O'Hara, 57 Cal 2D 476. Summary of facts and issues. Defendant real estate brokers refused to rent the premises to plaintiff solely because of his race. The real estate broker argued that because they were acting as agents on behalf of property owners, they required consent by all parties to rent to the plaintiff, who was African American. Since such consent was not proven, they could not be accused of denying services to plaintiff on the basis of race. Impact of the ruling. The court held that the Unruh Civil Rights Act applies to real estate brokers when acting in their professional capacity. As such, they were prohibited from racially discriminating against protected classes in real estate transactions, even if purportedly acting pursuant to the instructions of their client. 1963, California Fair Employment and Housing Act, Gov. Code 12900-12999, formerly Health and Safe Code 35700 et sec. The Rumford Fair Housing Act. Summary of facts and issues. The California Fair Employment and Housing Act, part of which was previously known as the Rumford Fair Housing Act, extended housing discrimination prohibitions to housing generally, and for the first time afforded an administrative remedy for housing discrimination. Specifically, the act prohibited racial discrimination in the sale or rental of any private dwelling containing more than 4 units, enforceable by specifically designated state commission. Impact of the law. The California Fair Employment and Housing Act, along with the UNRRA Civil Rights Act, represented the move for fair housing legislation at the state and local levels across the nation. These state civil rights laws predated the federal civil rights laws of 1960s that prohibited discrimination in employment and housing. 1964, Proposition 14, formerly Article 1, Section 26 of the California Constitution, repealed November 5th, 1974. Summary of the facts and issues. This proposition repealed the Rumford Fair Housing Act by adding a state constitutional right for persons to refuse to sell, lease, or rent residential properties to other persons on the basis of race. The ballot referendum was designed to repeal state and local housing discrimination laws. It passed in November 1964 with over 65% of the vote. As such, housing discrimination on the basis of race became constitutionally protected. Impact of the proposition. After its passage, the right to discriminate in housing on the basis of race was enshrined in the California Constitution, and those practicing racial discrimination could invoke express constitutional authority with respect to their residential property. Proposition 14 was overturned by the California Supreme Court in Mulkey versus Reitman, 1966, 64 Cal 2D 529, discussed immediate below. A decision which was upheld by the United States Supreme Court in Reitman versus Mulkey, 1967, 387 U.S. 369, discussed above. 1966, Mulkey versus Reitman, 64 Cal 2D 529, summary of the facts and issues. The defendant owners refused to rent any of their unoccupied and available apartments to an African American couple or any other African Americans claiming a constitutional right to do so, pursuant to Proposition 14 discussed above. Impact of the ruling. Finding a violation of equal protection under the 14th Amendment to the United States Constitution, the California Supreme Court overturned Proposition 14, striking down the California constitutional provision that prohibited the state from restricting a property owner or landlord's right to refuse to sell or rent to qualified citizens on the basis of race. 1971, Stearns versus Fair Employment Practice, Com 6 Cal 3D 205. Summary of the facts and issues. Ernest Cooper, an African American man, attempted to rent an apartment from Val Stearns. Mr. Stearns required him to submit a credit check before Mr. Cooper could rent the apartment. 3 hours later, Mr. Stearns rented the same apartment to a white person, soliciting an immediate deposit without requiring a credit check, offering the white person occupancy as soon as the apartment could be cleaned. The Fair Employment Practices Commission found that Mr. Stearns discriminated against Mr. Cooper, and Mr. Stearns challenged the commission's decision. Impact of the ruling. The California Supreme Court affirmed the lower court's ruling that the landlord discriminated by erecting a bureaucratic barrier to Mr. Cooper's occupancy of the apartment that had not been similarly instituted to a white man. Since such a procedure could be used to completely discourage or delay an African American applicant until an eligible white applicant could be found to fill the vacancy, The court concluded that Mr. Stern's behavior constituted housing discrimination. 1991. Walnut Creek Manor versus Fair Employment and Housing, Com 54, Cal 3D245. Summary of the facts. Robert Cannon, an unmarried African-American man, filed a housing discrimination complaint with the California Department of Fair Employment and Housing against Walnut Creek Manor on the grounds of discrimination on the basis of his race and marital status. Mr. Cannon was placed on a waiting list for the 418-unit apartment complex and was told to check back every 6 months, as the waiting period was 1 to 1 and 1.5 years. More than 2 years later, it was shown that the rental manager made no attempt to offer Mr. Cannon available apartments, but did call on other non-African American applicants who applied after him. It was additionally shown that after the rental manager met Mr. Cannon, he designated him as an undesirable tenant, but after the department commenced its investigation, she altered the code rating to desirable. Other acts of discrimination were also considered by the court, including the rental manager renting 32 apartments to non-African American applicants after Mr. Cannon's complaint. After the California Fair Employment and Housing Commission, which at the time administratively adjudicated housing discrimination claims, determined Walnut Creek Manor violated California's fair housing laws, the court appeal affirmed authorizing the commission to award unlimited compensatory damages for housing discrimination, but found the commission's award of general compensatory damages for emotional distress violated the Judicial Powers Clause. Impact of the ruling. The California Supreme Court held that rental managers' refusal to rent to Mr. Cannon because of his race constituted one violation of the Fair Employment and Housing Act for the purpose of authorized remedies. The court determined that multiple acts of discrimination against the same complainant on the same unlawful basis establishes only one unlawful practice. As such, the act authorized only one punitive damages award for this type of discriminatory conduct. And that will conclude tonight's reading of Chapter 35, Housing, Federal Statutes, and Case Law of the California Reparations Task Force Final Report. Before you go, if you haven't done so already, don't forget to like this video, hit the bell for reminders, and subscribe to our YouTube channel. When you go, don't forget to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and Twitter at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and info on our Get Involved page. Get involved. Support our work by volunteering and or donating. To donate, just click the Donate tab on the homepage of our website. Special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Thank you all so much for your time. I appreciate you all. We are closer to reparations than we have ever been in California. Have a great night.